Greetings, welcome to thctrust.org. This is going to be an advanced video, and I want to share with you some information I found. It's very important. I think it's important. This is to me, it's the most significant research I've done this year outside of status correction, secured party creditor, but actually this is within that because this deals with the securities aspect and how I structured the secured party creditor. Actually, let's say the national filing and then the secured party filing. I structured it based off of what they are doing to the person. So we all know everything starts with the birth certificate, the administrative estate, as we call it. And if you follow our work, then maybe you understand that they use the administrative estates to charge accounts, create interest, create securities, and basically to create money, if you will, or let's say to create currency, for lack of a better term. Now, one of the things that many people have failed to understand is by what authority do they use. Now, we know things such as the Sesta KV Act. Well, there's much legislation, and they all read the same way. They all talk about circumstances that exist where there's a minor who's incompetent to administer his own estate, or they talk about securities that have been issued without a trust indenture or a trustee appointed to manage the interests, etc. So when all these different laws equate to how the proceedings take place in admiralty and equity. Now, most of us have some type of cognizance or understanding that the structure of the law of the United States in America comes from the Constitution, and Congress has the authority to enact positive law. So what happens is, with this authority, Congress has assigned various powers to different administrative agencies. So these are like assignments. And what I found when I studied trust and equity law is that assignments are absolutely valid. They take them as valid. As far as transferring rights, for example, such as in your mortgage, and you have a servicer, he's a form of an assignment, and you can argue the fact if you want in the equity court, and usually you'll end up getting foreclosed on, because even though you may argue about your rights, there's some, it seems as if they're just ignoring your rights. And part of the reason is because of the nature of a equity proceeding. And the nature of the equity proceeding doesn't necessarily require a trustee to verify or validate a claim per se. It is taken on face value, if you will, and you can't necessarily challenge it in an equity proceeding because that's not the place for that. So in reality, you have to, I guess, correct the matter before you get to the proceeding, or when you're in the proceeding, you have to the way you correct the matter is not by challenging it, but by correcting the matter outside the proceeding and directing the proceedings to the resolution that you created. Do you understand what I'm saying? Equity is a different, what I'm understanding about trust and equity law, it is not the place to challenge, because you're only going to get rolled over. It's about the proceeding, carrying out the proceeding. So the most that you can do is illustrate the whole proceeding. And the way you do that is by bringing trust indenture, bringing your bylaw and positive law, because you're going to find that most of the trust and the securities law, the law that gives them the segue into your estate, is always there because of the fact that you haven't done certain things. One of those main things is express the trust that you're operating through, that's governing your estate. There's So what they are doing when we talk about the agency and the blind trust and the estate and all of these different things, they are absolutely operating through constructive trusts that is set up on the administrative estate of the person that you call your name. A there's really a procedures that they follow. There's delegations of authorities, there's trustees, there's secured creditors, there's beneficial owners, there's beneficial interest holders, there's authenticating agents, there's registered agents, there's all of these different parties. And one of the things that I found is that you are in the position of the paying agent. But I don't want to get too far ahead. I hope I've sparked your interest. We're going to go ahead and log in, and I'm going to go through these three forces of law that are at play. I'm going to just kind of show how they interoperate, how you have to be aware of all of them so that any one action that you take satisfies the obligation of all three of these jurisdictions. The trust equity jurisdiction, I guess you can call it, the common law with the trust. There's some trust in there too, but you got the equity, the common law court of record, and the admiralty. And these three things are interacting. And although, and I think if you polarize yourself to any one and you don't understand how to operate in all three, and it's not a lot of work, you just have to understand how they interoperate so you can just, if not, they use one aspect to prejudice your standing. So we'll get into that. Foremost, if you've never been here before, go here and log in. If you don't have a login, you can create an account right here that's free. So I'm going to log in real quick. And by the way, you might just have to follow along. You may just have to follow along. Looks like I'm already logged in because, let's try one more time here. I'm going to try to, sorry, bear with me here. I'm going to log in down here. Okay, so the majority of people who create an account on thctrust.org will have access to most of this. I kind of set this up in such a way where this is the basics. So if a lot of what I was just saying is totally over your head, you really got to start researching, because this machine of government is going to continue to govern your affairs, whether it's through child support, whether it's through managing your family and your children and who has custodian and all of that stuff, whether it's through managing your behavior through different statutes and codes, legislative prisons, right? The way that this is set up is that everyone must participate in the public, and the only way that you can be, let's say, free or lack of, for if that's your endeavor, is you have to have the knowledge and you have to operate accordingly. Anyways, I'm just saying you really got to get in and study somewhere. This is a good foundation. I try to set this up where it's progressive. Information about Moors, I'm going to put this here. You don't have to be a Moor to do the majority of stuff here. I want to treat these subjects as separately, although there's some overlap. I'm just putting this here for information. I don't deal with nationality, recording documents of nationality. Check with your local Moorish Science Temple of America. I am checking with my temple, and I'm communicating with them. And if they want to do some things to reach out and help people that's around the United States and around the world, then I will post this information here as I get it. But right now, if it's not there, I just don't have the information yet. Log in for free, check the information out. Go through the foundation, contract law, trust law. That's kind of setting you up for the basics of, and there's a lot more in between there before you get into what we get into today. The administrative estate, again, this is the person, the name on the birth certificate, the agency. This is the construct, the instrumentality of the United States that is used to facilitate commerce, right? To create currency, and that type of thing. That whole game where there's business going on, and that is where equity law, admiralty law, and these higher realms of jurisdiction are taking place. They've told you everything about the legislative and statutory jurisdictions, and they've conditioned us to rationalize things in terms of right or wrong, so that whenever there is a controversy or proceeding against the estate, that we become forced into being the blind surety agent because we do not know how to conduct business. We are blind to the business that is being conducted, and all we know how to do is sign, which, by the way, places you in the position of what is known as an authenticating agent. And see, this is what happens whether it's real estate, funding a transaction, criminal proceeding, citation. It's always sign something. Whatever it is, you're signing something, and you don't quite understand that there's a whole delegated trust structure. There's laws that deal with this specific thing, and you're handing over a security, a blank security, for an administrative agency administering equity for some beneficial owner, you in another realm, if you will. But you're unaware of it. And what happens is, when whoever you're handing this authenticated security to, you know, in order for them to cash it at the treasury, they need to countersign it. So then they also put an endorsement on the back. And what happens is they basically cash or invest it. It gets converted into another type of security, and eventually it gets titled and bundled and held off into an account somewhere, ones and zeros. And that ones and zeros in that account collects interests, and that's because the original property has went through some process and it was invested. And the original grantor, who was the grantor of that? Remember, I said you were the authenticating agent, right? And these positions are, they're absolute positions. I'm not making this up. We're going to go to those securities and trust laws, and that's the focus of this. I want to show you where these laws are. So now when you're dealing with your issues in these courts, you can start dealing with them from equity and trust standpoint, knowing who the parties are, knowing what they're entitled to, not asking text, should I be to this party, should I be to that party, comprehending what each party is entitled to. I will say that I believe there is no wrong party. From what I've seen and the remedies I've seen, I'm mentoring under someone, there's no wrong party, because technically you are all parties, but never in the same jurisdiction, for if you will. I mean, for example, look at a mortgage situation. You know, as the grantor, if there's a deed, there must be a grantor. So a security deed and a deed of trust, you are the grantor, right? The servicer or the bank or whoever that never gave you anything, they're just a trustee, and then they hand it off to a servicer who's servicing the face of the contract. They're doing all this for the grantor, but see, the servicer is disconnected from the grantor, right? Because the servicer was assigned his powers by the bank, who has a responsibility to the grantor. But the servicer is disconnected, so he's servicing indirectly for the grantor. Not directly, but indirectly for the grantor. And it's because he's indirectly servicing for the grantor, he doesn't necessarily even have to know who the grantor is, right? The servicing company doesn't really have to know who the grantor is. He just receives the information in the contract and the debtor and all of that from, you know, from the original trustee, right? So it's an assignment that has taken place. And that's why I was telling you, when the foreclosure, for example, or you could take this into any type of equity proceeding, you know, you start arguing all these different things about the banks and the rights and all this, but while you're arguing, they're only dealing with the proceeding of the servicer serving his contract and executing whatever is under that contract. Because this is an equity proceeding, so they're looking at it. He's the trustee, he has the contract, he's the receiver. So how do you resolve this? The question then comes, in this jurisdiction of equity, estates and trust laws, which is always going on, by the way. So there's something that you're always not doing that gets you trapped in the legislative jurisdiction. And one is you're just not operating on that level. No one's in there talking about securities, trusts, equities, and all of this type of stuff in any of the family court proceedings or any of that. And I'm not saying that you have to be in there talking about it, because really you wouldn't be in there talking about it. If you was dealing with these parts of the proceedings, there wouldn't really be much verbal to say. Everything you would be doing would be administrative presentments to administrative offices of courts and things like that. And there may be a couple of things that you send to the judge, motions or whatever you want to send them, affidavits, and you may send them to him in camera or whatever. But rest assured, whether it's in the court or whether it's out the court, is equity proceedings. And to get back to what I was saying, let me demonstrate that by my research, it appears that in this whole trust structure, and I call it a trust structure for a reason. When you look at the Sesta KV Act and all the modern laws that come after it, the modern laws being things like the Trust Indenture Act of 1939, the Uniform Gifting to Minors, and all these different acts that deal with the registration of land to minors and estates, and all of these things. For example, the Trust Indenture Act of 1939, when you go into the purpose of why it's written, it suggests that securities have been issued and the issuers didn't appoint a trustee, or the grantors didn't include a trust indenture, and therefore to govern the securities they create a whole public structure so that a trustee who's delegated the authority based off of whatever interaction and transaction with you can now go in with your signature as an authenticating agent. He can go in and create back-end securities, invest, reinvest, create bonds, whatever, and pay himself out, because under trust and equity law, trustees, intermediaries, and custodians, they always get paid out first with every transaction. Every time they're doing something, they're getting paid out. While all this principle, because remember they're trustees, so they're holding property. What are they holding? They're holding the security that you authenticated with your signature on it. They countersigned it and then started doing the business. So I was saying a trust structure because it's a structure that allows them to do this, and they wouldn't be doing all this if they weren't making money. Where are they taking these signatures? They're going to the government or to the treasury. That's where these corporations and such are taking them to cash out and get funds in their account. So they have these structures put in place, and the authority comes from the fact that you are not operating in trust. Just like the Sesta KV, there's no evidence of life. It always goes back to something that obligation that you're not doing, which is why they're taking the liberty to administer and do for you, right? This is why you have indirect holding system. And then those people that wake up and catch on, then they get to the Treasury direct holding system. Notice this polar difference. A direct holding system versus the indirect holding system. The indirect holding system is kind of like the trustee is holding everything and managing your beneficial interest too, and just leaving you with the responsibility. So anyways, I laid out kind of what's going on. So we're going to go ahead and I'm going to touch on one thing, then I'm going to direct you to the resources. The reason I'm directing you to these securities laws is because basically we need to learn how to operate in trust. And this is going to be the answer to many things, because they're creating constructive trusts and delegating authority to do business in a blind trust, and you are becoming the responsible and obligated party. So you have to learn how to operate in trust. There is a rhyme and reason to everything that's kind of taking place, and those are the forces of the common law, the trust and equity, and the Admiralty. These things are at play. So I'm gonna go ahead into this now. By the way, I was saying you can go through here. This is your introduction. There's hours and hours of worth of video and material, and I've been in here updating stuff. especially down here under the advanced topics, mortgages and foreclosures. And of course, there's always good information here, but to get access, total access to, because when you click these, there's different sub menus and such. So let's see, mortgages and foreclosures. See, there's some templates. Here's the mortgage blueprint that I'm working on, and I'll do a video about that next. But anyways, so you can go through there. But now let's get into here. This is where you'll find the references of where you can study. Now you have to study these structures, not because read what each of these laws I'm going to give you are. You have to be familiar with what they are doing, because a lot of things you can fix by simply doing an appointment, an assignment, a fiduciary appointment, appointing them to do something that they delegated to you. You see what I'm saying? They're always delegating because there's no indenture and there's no assignment and no authority has already been expressed. So all of this is leading back to what? Your status correction, obviously, because you have to demonstrate in commerce that title is held in trust and what the provisions of that are, at least to the extent to secure the securities coming from the estate. And that's not all, but that's so before I read through this part, which you'll kind of go over, you can see them right here if you want to start Googling if you don't have access to this. You got to be a premium member, or you could check it. Maybe I might keep it open for everybody. I might just keep that open for everybody. I think so. Why not? That is what I'm going to do. You don't have to be a premium member. But you premium members, you will have access to the mortgages and foreclosures, and that won't be for everybody, because that is where we're going to start applying what we now know about trust and equity. Because I'm mentoring under a gentleman right now, a friend of mine. We've been in this whole thing for about the same amount of time. He's only focused on foreclosure remedy, and by the way, he has success. So if you're in foreclosure, post foreclosure, contact us. We formed an association. It's called JAS Association. But if you need our assistance right now, you have to have a minimum of $3,500 to $5,000 to invest in your matter, whether you are in foreclosure presently fighting attorneys, whether the foreclosure is coming, or perhaps you're not in foreclosure and you are up to date and you want to entertain removing the encumbrances and holding title free and clear the way you were supposed to. The way that my colleague has been able to get this success, I've seen him win against attorneys, is simply the knowledge of trust and equity law, and then bringing it all together. And that's kind of something I want to kind of go into, and this is why I'll start right here. I have these three things on a screen here. This is the kind of the way that I begin to see things in my research. Let me go up here and read this first part. Trust, equity, and admiralty are the systems of law, or perhaps forces of law, that government and private persons use to claim and divest any estate, person, or account of equity or currency. It follows the rules of common law, where its authority comes from the federal statutes and the Commerce Clause in the Constitution, where the United States outlines the Congress's authority to legislate federal statute to do these things. So basically what I'm saying is you have the common law, the trust equity law, and admiralty, and these things are moving together. And I want to show you where you get glimpses of them. In your county, that is where all the common law stuff is taking place. I put this term divest here. There's another term, devolution is what they call, because common law only deals with rights. Rights only deals with real estate and your interest or ownership of real estate. These things are of the common law, right? They say ownership is under the common law. You own things. So what happened with when I say use the term divest, when they had the Birth Registration Act, the Land and Titles Registration Act, vehicle registry, everything that was a registration, was was a way to um, record your entitlement. You know what I'm saying? That was a way to devolve or convert your real entitlement into personal entitlement. So it's almost creating an accounting for a real interest that you own. They put it into personal interest, or create an accounting, or they put it into an account so that it can be aliened in equity. You see, so this is what basically is a form of what you would see as attachment in the uniform commercial code, if you will. So under the point I was making is, so what I'm saying is this: when you look into your county recorder's office, you will see things such as warranty deeds and grant deeds, and they're usually the initial records that are open showing a freehold claim and land. A warranty deed demonstrates real estate. There's a difference between something that's known as real estate and real property. The difference is real estate is a freehold in land. So that is what's demonstrated in a warranty deed and a grant deed. There's no terms and conditions. There's no note, balloon, mortgage, adjustment. None of that stuff exists. It's just freehold and land, and that is termed real estate. But if somebody has a lien on your real estate, they have an interest in your freehold. So their lien is what's known as real property. Real estate, as I said before, is also under the category of real property. So real property includes liens, encumbrances on real estate, as well as real estate. All that is real property. But in reality, real property is a devolution of real estate. It's a way for them to put a claim on your estate. But anyways, there's a reason why there's a point that I'm getting to, and you'll see that in a second. So under the common law, you know how they say common law court of record? So that's kind of like a clue. If you have rights, they're going to be on the record. If you have a title, you have a title. You have a deed of title. If you have a lien, that's an example of a right. It's everything on the record. Notice that the record, you can pretty much access the record unimpeded. I say that with certain reservations, because some people don't know how to get certain things filed. So they will say, they won't let me do this. But really, what I see is your common law record is where you illustrate everything. Because when you get into equity, which is at the state level, right? And this is why they're dealing with certificates at the state level. Business certificate, certificate of good standing, birth certificates, they're issued by the states. These are all things of equity. Equity deals with certificates, certificates of service, certificate of whatever. So equity talks about two types of certificates: voluntary certificates and involuntary certificates. But the correlation that I want you to see is when you're dealing with your common law rights, you're dealing with affidavits and deeds. When you're in equity, you're dealing with certificates. So one of the things that we found is certificates are more powerful in equity. Hence, you would use a certificate of service over an affidavit of service, right? But I'm going to explain the correlation between the certificate and the affidavit shortly. I think I have to do a whole separate video about that. So let me just explain it real quick. A certificate is proof of a thing that has already been done, right? But a certificate may have to be proved, and when a certificate has to be proved, it has to be a fact on the record. So anything that you have a certificate on must be able to be proved, which means it must have a page in a book number entry on a record somewhere, or some other type of entry on a record. Hence, if there is a certificate of service, there must be an affidavit of service somewhere. The certificate is proof of a thing that has already been done. So take, for example, let's talk about the straw person with the birth certificate. If you look at the birth certificate, it shows, let's just say the birth certificate is issued by the state, right? but there's county information on it. It shows who the county registrar is. It shows that the date that the items or articles were received, right? So there's evidence of a county registration right there. So the certificate of live birth is proved right on its face because it has a county registrar, whatever, whatever. So there proves there was a county register, so it's self-authenticated already. Um, if so, this is something I also learned with administrative procedure. So if I do an administrative procedure, you want to do an affidavit of service, an affidavit of non-response. You're going to the same notary, getting her to stamp your affidavit of service, and she can give you a certificate of service. Um, and actually what'll happen is you'll go to the notary, you'll show her the contents of the envelope and all of that. You'll go, mail it out, and you'll do an affidavit of service. Based off of the affidavit of service, she can give you a certificate of service, and you don't need a certificate. Only you could get affidavit of service, affidavit of non-response, this, that, and the other, as long as you had a notary witness your process. And if you ever need to bring the certificate, then you get a certificate from the notary. You can always put a certificate on a thing that was done. So affidavits of service, affidavits of non-response, affidavit of whatever. If you ever have to take that record into the equity, go get a certificate of acknowledgement on it. Now you have a certificate to be used in the equity because they're paying attention to certificates. So if you're trying to do something and your affidavits are not working, bring it in as a certificate because that's what they're paying attention to. Now there's two types of certificates in equity, voluntary and involuntary, but I'll skip over that because it doesn't really kind of fall into here. So, to further drive, okay, in Admiralty, by the way, Admiralty deals with the movable goods, how the foreign creditors take your accounting from the record through the equity proceeding, and then the arm that pulls it into their books, so to speak. Movable goods, the adjustments, that's where Admiralty comes in, the governing oversight. Once again, that goes into the divesting part. This is the county is really just registration. The divesting part after the equity proceeding, equity and Admiralty kind of overlaps, but and they say Admiralty is war in commerce because it's moving. Things move along the track. They move from position to position. When you're a surety, they're divesting from your estate. The motion is the part that really is where the Admiralty proceeding is. That's the Admiralty part. So these are always taking place. You understand? So I'll give you an example. Affidavits. An affidavit. Well, I'm not going to go any further than that. I talked a lot about indexing in other videos, so I hope you guys kind of caught that. Let's see, is there anything else I need to say down here? I said real property includes both real estate and personal estate, right? Real estate is an interest in real property, not less than one's life. That's just the land. Personal estate is what happens when you take a warranty deed and then you put a grant deed under it. You took your real estate and you assigned some type of interest, and that now became personal estate. De-evolution. And when you assigned that interest, you assigned a trustee, and then it all went downhill from there because you didn't know anything about trust and estate law. Alright, okay, let me take a break. I'm going to come back and... No, I can't take a break. I got to go all the way through this. So I'm going to read what I have here, and then we'll close out. But what I want you to get from this reading is that as you begin to go deeper in your understanding of trust and equity, and you begin to look into these references and understand how courts go about using your signature to create various types of bonds and how they pay different accounts on those bonds, and you begin to hopefully understand the principal interest that is due back to the estate when you learn how to set up and manage the estate. You will be able to deal with your situations more competently because you'll start dealing with the trustees by name. You'll start appointing proper paying agents, proper fiduciaries. You will know how to countersign your own securities, how to issue instructions. But anyways, trust and equity and admiralty are the systems of law or perhaps forces of law that government and private persons use to divest any estate, person, or account of equity or currency. The 1930, I'm going to skip a little bit here. The 1933 Securities Exchange Commission, the 1933 Securities Exchange Act, that deals with public securities. Any Wall Street broker that you can think of will be familiar with the 1933 Securities Exchange Act. Most people, traders, and things like that who have any legal dealings with stocks, bonds, mutual funds, and things of the such in the public, they're familiar with the 1933 Securities Exchange Act because that is the public side of these debt securities. The 1934 Securities Exchange Act deals with government and private securities. I think the 1933 is called the 1933 Securities Act, I think it's called. And the 1934 is called the Securities Exchange Act. I believe that's correct. Anyways, this deals with the private equity, and it also deals with government bonds, which is a lot of private equity that was created off of estates and the people. But I'll explain a little bit of that later. But what was happening is you always have to invest private assets and private securities to create public securities, or the type of securities that would be covered under the 1933 Act. So investing in these 1933 Act publicly traded companies that got prospectuses and different things, there are certain rules and regulations that have to be in those as they are presented to the public and all of that. That's kind of maybe what this deals with. But all the assets and underlying securities and private equity that some is claimed, the majority of it, I bet, is unclaimed, but held, entitled. There are rules and regulations that deal with the trustees and secured creditors and everyone else who's managing and doing the affairs with those securities, making the money off of those securities, even though they're just holding it in intermediary capacity. Why? Because either for the most part, the beneficiaries of these various estates, they're unaware. These various securities, they're just unaware. And this is the plan to continue. A trustee payout would have to be ridiculous when accounts are in billions and billions of dollars. Whatever percentages that they would be entitled to is ridiculous. But the 1934 Securities Exchange Act deals with the private securities and how these things can be invested. Because remember, these are private securities. Things with your signature are private, and then they get invested, countersigned, negotiated to the Treasury through different investment programs, Treasury investment program, tips, and things like that. So you have to be familiar with who the parties are, because all of these things are only allowed to exist because you have not expressed the trust indenture. And that doesn't mean that the answer is you just write a trust. Part of the answer is what we're doing right here. More of the answer is learning to operate in trust. You present the trust indenture to the intermediary, or you revoke the powers, or you appoint the trustee. There's certain actions that you do. So it's not just having a trust indenture. That's not going to fix your solution. Throwing a trust indenture at someone's not going to fix your solution. Overstanding the authority from which they're coming and where they operate, where the United States delegates them authority in the absence of what you should be doing, is where your resolution comes in. Knowing what you're talking about when you go in there. So that's why you got to get into these. The 1934 Act deals with I'm going to say in part private equity that comes off of these various estates that you don't even know about, that we're not even hip to till right now. This is why we talk about secured party creditor. You're securing private equity. When you put a lien against anything, you create a private equity, a private security, such that does have value but is not governed under these public laws. Even the 1934 that deals with private securities still doesn't really govern private securities. It just talks about beneficial ownership, affidavits of beneficial ownership, and uh, what that means, pretty much how to pay that out or whatever, if you will. I'm just kind of generalizing. And really, that's not so much under the 1934 Securities Exchange Act, because that act led to the creation of the Trust Indenture Act of 1939. Um, Recommendations to Congress, 1934 Act required Congress to make some recommendations or something, and then they came out with the Trust Indenture Act of 1939. Now, this was presented in such a way that it was there to manage the way that trustees and these different parties that's participating in business that you don't know about, doing this blind trust stuff on the various persons' estates, they were investing in these things, probably creating absorbent amounts of interest, because intermediaries and custodians get paid out first under equity and trust law. So all this equity that they're administering, because you authenticated something, because you're a grantor and authenticating agent for a person, they start acting as a trustee for a person. The Trust Indenture Act goes into a lot of that, and there's other laws. The Securities Exchange Commission Act will take you to those. You can click these; they're hot linked in. But this I found was the most useful. This is called the 1983 Model Standard Indenture, and right now that has really opened my mind to a lot of things. For one, it's clear to me now that they have you in what's known as the paying agent, because the United States laws have pretty much delegated that if you present, if you're presenting, this is under the bankruptcy, basically the bankruptcy laws, and they're presenting a company with an obligation to pay, and that company goes in default for 90 days. When the trustee, any of these courts, that by delegation of authority, when a secured creditor brings a 90-day continuing default claim to a trustee, the trustee has to pay it out immediately under trust and equity law. So when they're defaulting you with these 90 days of letters and all of that, it doesn't, if you're arguing the wrong things, it doesn't really matter, because when he takes the procedure to the equity court, to the trustee, it's not the trustee's duty to verify the validity of their claim. If he done anything to really follow the law, it's probably just so you don't come back at him and sue him earlier. Trustee is not going to verify validity of the claim. He's allowed to work off the presumption, because equity and admiralty is only about business. So the only way that you can really resolve this is by knowing who the parties are, what they're entitled to, and how to change who the parties are. You got to fix it before you get to the equity and admiralty proceedings. The way that you do that is by establishing the record. Remember, the delegation of authority under these federal statutes comes because there is no indenture. So you have to have something. Where does your certification of trust get recorded, or your memorandum of trust? Actually, common law court of record. And that's, again, don't get it twisted. I'm just trying to show you the relation. Don't think that you just record a trust and that's going to fix everything. There's layers to this. If you really want to go into correcting the person, of course, you can go to the secured party creditor thing right here. You donate the $150 and go through the master file and blueprint and do it for yourself. You see what I'm saying? But we've taken these things into consideration. I think even stronger than putting any type of trust indenture, memorandum, or certification of trust in the record, well, you have to do something first. You either have to put an affidavit of beneficial ownership on a birth certificate or a memorandum of trust, because you really cannot do anything in equity unless you first have title under the common law. And where's the common law? We said it earlier, at your county court level. So that means you have to have an affidavit, which is a claim of title on the record, or a memorandum of trust demonstrating title. Why? Because then if you find yourself in an equity proceeding, they're looking at, well, I don't want to get ahead of myself, But what I do want you to know, and I think I'm going to close out after I kind of touch this point a little bit, is that the way that you give yourself positioning in equity is that you have to be able to illustrate, correct, or express the record. Because in equity, they're looking for who's trustees, who's custodians, who's a beneficiary, who's a secured creditor, who's an authenticating agent. So by assignment, and when I say assignment, that's your deed. That's your deed of trust or an assignment. Similarly, assignment in a record. By assignment on the record is how you establish who these positions are. Remember, the courts of equity will look to the common law court of record. Usually the problem is there's nothing there. So we don't have anything on the record, but we're asserting rights. Because remember, if you had rights, they were due to be registered. Birth Registration Act. Right? These all these land titles, and it's all real estate and personal estate. I hope I'm not like going over everyone's head. I'm hoping I'm tying some things together. I feel like a little bit like I'm all over the place, but let me know how you like this. If you got something out of it, let me know. But what I was gonna say is I think is the strongest way that you can operate. It depends. It deals with your UCC filing and evidencing in your UCC filing that the secured party is a trust vessel. That is really key. You have to evidence that your secured party is a trust vessel, and that trust vessel has to have proper indexing over the estate, and that has to take place in your county level. So what I am saying is you have to have a county recording or registration in place properly in order to be a secured party and to be registered property in Admiralty to secure your state and everything else. That wasn't what that's all about, but what this was really about is showing you the direct tools. One of the things, so potential remedies that came out of this, right? And again, this 1983 MSI model, I believe that this is a structure. This is a model standard indenture. So this is, although it's not written to say this is what this is, but I'm going to tell you in my own words by everything I studied what this actually equates to. This actually equates to the structure that they are using to administer your blind trust. This is kind of the ways that they're doing it. And by backward engineering what they are doing in here, learning the terminology, you can come into court proceedings appointing who proper trustees are, valid assignments, revoking powers. It's endless things you can do, but you have to know how to do these things, and they have to take place as a matter of record, because trustees are managing receiverships, and all of these different people that acting as trustees, they're managing property. But the grantor directs and orders what takes place with the property as a matter of record on the common law and the common law court of record. They look to the record, right? Without the record, legislative jurisdiction takes place, and they operate with things such as this right here. It didn't come up. It's going to pop up here shortly. Where did it go here? Bear with me. Anyways, I'm not happy about that not coming up. Anyways, you can click on it. Go into the website. You can Google it, 1983 Model Standard Indenture. and and what you'll see is, I believe that is the structure that they are operating from. That shows who the paying agent is. That talks about a 90-day continuing default on the paying agent. Trustee, secured creditor takes it to a court, and the court is just paying it out in an equity proceeding. While you're arguing about everything about your rights, you have no, there's no record of your rights. And it goes deeper than that, because there's rights and there's responsibility and there's liability, and all of these things are separate interests. You have to create the whole scenario. Once you create the scenario, once you get to the equity proceedings, it's gonna play out the way that you wrote it. I hope that makes sense. Um, Visit www.thctrust.org, log in, create a free account. Peace.